So, Mary, we're going to begin with you because you are a primary in this subject. Tell me about this suit and tell me about how you read the Supreme Court's decision.
Sure. The suit that we brought just one day after the executive order was on behalf of 5 pregnant women and 2 immigrants' rights associations on behalf of their members. They are membership organizations, CASA and ASAP, the Asylum Seekers Advocacy Project, that have members nationwide, many pregnant members. These included women and pregnant members of ASAP and CASA that are from multiple different countries, that oftentimes are here on a legal status, because remember, the executive order does not just apply to children of undocumented immigrants. It actually also applies to children of immigrants who are here lawfully but temporarily. So that means a work visa, a student visa, temporary protected status, asylum applications, people who have permission to be here. We brought that case. We obtained a full nationwide universal preliminary injunction within 2 weeks of bringing the case. And that was one of the cases that the government went to the Supreme Court to say, don't review right now the constitutionality of the birthright citizenship order. Our judge and every other judge ruled that it was unconstitutional in violation of the text of the 14th Amendment, historical practice, and binding Supreme Court law. The government said, don't look at that right now. We're just appealing the scope of the universal injunction. We think it should be narrowed down to the plaintiffs. What the court did today was the majority was agree that the nationwide injunctions do not date back to the time of the founding. There are a lot of differences between the time of the founding and today, you might recognize. And so therefore, it needs to be limited to what is necessary to provide complete relief to the plaintiffs. They did leave open, though, that, and again, this decision says nothing about the merits of the birthright citizenship order, which is flatly unconstitutional. It is a procedural ruling. In response to that, and because not only the majority, but also in separate concurring opinions and dissenting opinions, really all the justices recognized that class actions are still available. And so on behalf of our clients and additional babies who have been born since this executive order and their mothers and their parents, we filed within 2 hours of the Supreme Court's ruling, 2.5 hours, a new class action amended complaint on behalf of all born and unborn babies who would be impacted by the executive order and their parents, and a motion for immediate injunctive relief for the entire putative class. So right now, the injunction we have already still protects all of our plaintiffs, but we think it's extremely important that all U.S.-born children be protected against the impact of this executive order.
And so will this class action suit end up working just like a federal nationwide injunction? Is that possible?
It is. That's why I say this is very procedural. I mean, there are reasons we didn't bring it that way to begin with. First of all, because universal relief had been available, and so we did not bring it as a class action. But the class action does have procedural requirements. We believe very strongly we easily meet those requirements. Those are requirements like numerosity, lots of people impacted. Obviously, lots and lots of people are impacted by this. Typicality, meaning their claims are typical of each other, right? Common questions of law and fact, all of that are clearly the case here. So if the district court agrees to issue a putative injunction on behalf of the putative class, which is something that the Supreme Court has also recently approved of, injunctions even at an early stage based on the putative class, the class that you've represented to the court should be certified, that would cover everyone across the country. It would have the same impact as the universal injunction. And we've asked the court to do that quickly, immediately, because even though the Supreme Court said that in accordance with what the government argued at oral argument, that they wouldn't start to do anything for 30 days, there is real harm right now. Pregnant women who have anxiety and stress about the possibility their children will not be born as U.S. citizens. We've seen cases where some women have had to actually be hospitalized because of that anxiety. We've known of some women who are thinking about trying to work with their doctors to, induce labor early in order to not be worried about this order. So it is having a real impact now. That's why we think it's important for the court to grant immediate relief. And remember, the court already ruled that the plaintiffs were likely to succeed because of the order being unconstitutional, in violation of binding Supreme Court precedent. And nothing has changed about that, because there is nothing in the Supreme Court's decision today that suggests that this executive order is a lawful order. This is purely about procedure.